Good morning, all. We got a lot of sleep. We will get right into it. It looks like it may not be too long a day unless they have unexpected things going on. May even have closing arguments today. So without further ado, let's get started. Thank everyone for being here. And for some reason, I can't see all my live comments. So I do apologize. I'm still working on that.
Day 8, I think, of the trial of Christopher Wolfenbarger. No. 9, 7, 9. Okay. Case number 24 SC 004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that the state's counsel is also present. I am told that the wayward witness is here, Mr. McDermott.
Yes, Your Honor, I have made contact.
Has the state had an opportunity to make contact if they so chose?
We have not, and we don't need to.
Okay. Is that witness up?
Yes, Your Honor.
Is that witness in custody?
Yes, Your Honor.
Okay. My general understanding is that the sheriff.
Wow, I am shocked.
To have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters while we're taking care of that we need to take up before we get the witness on the stand? Anything from the state?
Nothing from the state.
Anything from the defense?
Nothing from the defense.
Okay. Yes, sir. So just to be clear, Mr. McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness, or do you want me to make an attempt to get her to answer directly first?
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such. Good morning. Ma'am, if you'll come over here to the witness stand. And she might need some assistance getting up onto the witness stand and situated in the chair. You could. Thank you very much. Okay. So we have our witness, and so I think we're ready for the jury, Deputy. Mr. McDermott, the defense may call its next witness.
The defense calls Wendy Waddell.
Okay. Ladies and gentlemen, as you can see, Ms. Waddell is already on the witness stand. Ms. Waddell, if you can, please raise your right hand to the best of your ability. The deputy will swear you in.
You swear affirm to the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yeah.
These statements be recorded and recorded.
Wendy, W-E-N-D-Y.
And if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Waddell, W-A-D-D-E-L-L.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Waddell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenbarger?
I did.
And do you know the Patton family?
I do.
Carl and Norma? And how did you know them?
My parents grew up with them.
And did you live next door to them at one point?
As a child,
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house? Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
Why did it smell?
Well, people just have a smell.
What was the smell like?
Like a person that
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling
Are
me?
you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about facts. You remember speaking with me on the phone a couple of weeks ago?
Yeah.
And you remember telling me that the smell pervaded the house
I
and the
did.
car
I got on the car.
and
Got on
stuck
the
on everyone in the house,
It did.
including Melissa. And you remember telling me that people bullied her for it,
They did.
picked on her? You remember telling me that Melissa had some kind of, it's not a leading question, Your Honor, unless it suggests an answer.
You're going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa has some sort of skin condition that caused her to have marks on,
Contigo.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I look back at it, I'd say autistic. I'm sorry. I said, if I had to look back, I would say autistic.
Okay.
She would be autistic.
But you're not a doctor, right?
I'm not
So you can't diagnose her with autism.
Yeah.
But what made you arrive at the conclusion that she may have been autistic?
just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's,
she quiet?
sure,
Was she shy?
yes,
Was she reserved?
she was.
Did she sometimes react?
She whined, she cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Like a baby.
infantile for her age?
Yeah.
You described to me a period of time in which you would visit her. Do you remember describing a time to me in which you would visit her almost every day,
Every weekend, yeah.
and that you would be locked in the room with her?
Yeah, growing up,
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door, so that the lock was on the outside?
I was.
And do you remember that she was telling me that she was locked like that every day, all day?
He's giving answers.
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer. I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it started at about age 7,
I'm sure it started early.
went up to about 12?
Yeah.
Okay. You said her sister was locked too,
He's right there.
and she was locked up too?
Mhm.
And
I'm sorry, was that a yes?
Yeah, my mom used to sneak over there and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes?
Yes, it is Terry Archer.
Thank you.
and
Is that a yes?
Yes, it is Terry Archer.
Thank you.
and what was your father's name?
Bobby.
And you said that your parents were wealthy
They are.
and that they paid to be involved in several activities with you.
They did.
What kind of activities?
GYOP. Georgia Youth on Parade. Girl Scouts.
You remember telling me that anything you did, Melissa
He
had
did.
to do,
That's right.
and that your mother paid for it. You remember telling me that looking back on the way she was treated, being locked in her room and being deprived. Well, let me back up. When you and Melissa were locked in the room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah, you're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get, what was that? We're thirsty.
you remember telling me that looking back, you would consider that she had been abused and neglected?
Yes.
Today, if someone were treating their child like that, would you call defects?
Relevant, Your Honor. Objection.
Probably.
Hang on one second. Sustained. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
They moved away? Okay. And about what age were you at that point?
I'm not quit hanging out with him when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
And how did that happen?
Objection. Relevance.
Sustained.
Okay. May I approach your own?
Sure. Sustained. Move on, please.
Do you remember telling me that? I caught myself. Was there a time that Melissa did drugs with you?
No.
Okay.
I was doing drugs.
And because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but it's just for the record. You got to let me finish my question and then you answer. Okay. Do you remember something? Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
And do you remember that there was something that led up to her running away from home?
Her sister had a steel baby.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
okay.
How I know that?
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, John?
Thank you. Ms. Hilton, questions for this witness?
Do you remember telling me that when you knew Melissa and hung out with her, that her mother would not let her have anything like makeup?
Said a yes.
Yes.
Thank you.
And what did she do instead?
Use colored pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks?
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I say that?
Can I show you a transcript of our interview?
Sure. I never said that.
Would you let me play the audio?
Sure. I must have been high.
Permission to share, permission to share, Your Honor?
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you just asked.
I can imagine she was traumatized.
She was traumatized. She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use colored pencils because her mama did not give her those things.
Oh.
You know, like she, would have to use, I hate to say it, but like socks for pads and shit like that. Because her mama neglected.
I guess it is. Help us out.
No further questions, Your Honor.
Thank you. Ms. Hilton?
Good morning, Ms. Martin. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his questions. Have you and I ever met? Is that a no for the record?
No.
And have we ever talked on the phone?
No.
Okay. And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
Mistake. I thought it was you.
Oh, no problem.
Go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes.
And so you were her next door neighbor, correct? Melissa's next door neighbor.
As a child.
And as a child, that from between the ages of 7 and 13?
No.
What were the ages?
Ages of 2 to 7
2 to 7. And your parents are friends or were friends with Melissa.
are friends.
And you said you spend time at her home every weekend, correct?
Did.
And you just testified that there was an odor in the home that she didn't like. Is that fair?
So yes.
Yes.
Thank you.
But every weekend you still go to the house.
Yes, I love it.
And I think you testified earlier that your mom would have you take Tina out the window.
She would.
But your mom still lets you go over there every weekend.
She did.
Now, you said that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and they just like a girl youth group. Is that the third thing you just said?
Something like that.
And it's safe to say that her mother will let her go with you to
Sure.
do these events. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington.
She did.
And so her mother would let her leave from Stockbridge, is that a yes?
McDonough.
From McDonough and come see you in Covington.
She would.
How far is that?
30 minutes.
So it's safe to say Melissa had to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know.
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Now, is it fair to say that the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the
We did.
Pattons would attend?
Yes.
What type of event was that?
Holidays.
And you talked about Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No.
Would she ever just stop talking to her children?
Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times?
No.
No, you didn't, or no, she
Yes.
wasn't? Sorry.
Yes, she's not right.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You described her as a type that would not fight?
She don't.
That she was very naive?
She was.
Not a smart thinker? Mm-mm.
Not a smart thinger.
You said that she's dependent on whoever she is with?
That's right.
That she would not be the leader in a
She
relationship?
would be.
Matter of fact, in your friendship, she kind of followed you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess very short. He would let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98,
Do you recall telling Mr. McDermott that was around Thanksgiving 1998?
something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone,
He did.
and he wouldn't let you speak
He
to her.
wouldn't.
And he was controlling her ability to talk to you.
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood
Objection.
friends.
Sustained.
It's true.
When there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
Court's indulgent. Sure.
Thank you. Mr. McDermott, any additional questions?
Yes, ma'am. You just told the state council that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
Nope.
Uh,
He said defense.
Okay. Permission to play some audio, Your Honor.
She said you said defense.
Okay, so I did tell
Just
you,
making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that
Okay, thank you.
afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know, what I say. And I hate to burst your little bubble. I'm just telling you, like, I do heroin every day and I'm going through withdrawals. And that's the whole point. I didn't want to come here. So I don't know what this would be.
Were you on heroin when you talked to me on the
was.
phone? You on heroin right now?
Only because I'm locked up. Sweating to death.
Just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that.
I didn't.
Okay. So you don't know what she was thinking or doing after that age?
No.
No further questions, Your Honor.
Thank you, Ms. Hilton. Anything else?
In that Thanksgiving 98 call that we just talked about, do you recall telling defense counsel that the patents were at your family's house for a family function? Is that a yes?
Yes.
And that it was during that family function you asked about
Her.
Melissa, and you said, "Give me a number so I can call."
I did.
No further questions.
Mr. McDermott?
No further questions, Your Honor.
Okay. Ladies and gentlemen, just for some logistics, I'm going to have to ask you to step out for just a moment. I'll have you right back as quick as I can. Church clear, you may be seated. Deputies, if you'll assist Ms. Waddell, she's excused as a witness. Thank you, Ms. Waddell. I was just going to say, I trust that her release will be processed as quickly as possible. Mr. So I understand what's going to happen when I call the jury back in. Does the defense have any other witnesses, or is the defense planning to arrest?
Defense arrest, Your Honor.
Okay, well, I'm going to need you to do it formally in front of the jury. I'm just asking in advance. Does the state still have planned rebuttal?
Yes, we have two witnesses for rebuttal.
Okay, and do you have them ready to go outside the door?
One is right outside the door, and the other is our DA investigator.
Okay.
basically.
Okay, so we're ready for the jury to come back in then, and we'll have the DA rest, and, or excuse me, the state will rest, and the DA can take up its rebuttal. Is that a yes, Ms. Hilton?
Yes.
Okay, so yes, Mr. McDermott?
I'm sorry, Your Honor. Question?
Okay.
Question again, please.
Are you ready for us to come in and proceed in the manner I indicated, which is that y'all are going to rest once the jury comes back in and the state's going to take up its rebuttal?
Yes, Your Honor.
Thank you.
Rebuttal is coming up next. So stay tuned.
Please be seated. Mr. McDermott, the defense may call its next witness.
Your Honor, the defense rests.
Thank you. Ms. Hilton, any rebuttal from the state?
Yes, Your Honor, briefly. The state will call Detective A.B. Calhoun.
Okay. If you'll come up to the witness stand, and before you, once you get there, if you'll turn and face the deputy and raise your right hand, he'll swear you in. Just be careful of that ledge, and then scoot up to the microphone and state and spell your name for the record, please, sir.
My name is Alton, middle initial B, Calhoun, A-L-T-O-N, again, B, C-A-L-H-O-U-N.
And good morning, Detective Calhoun. How are you?
I'm doing fine.
I want to direct your attention specifically to April 7th of 2003. Did you have the occasion on that day to speak with Kimberly Cameron?
Yes, I did.
And how did you make contact with Ms. Cameron?
I made contact with her, phone contact with her.
And who, at the time, did you know who she was?
I knew that this was a very close friend, well, a very close friend of Melissa Wolfenbarger, and also Chris is Wolfenbarger's sister.
And did you speak with her on that day over the telephone?
Yes, ma'am, I did.
And what, if any, let me ask you specifically, was she able to tell you about her relationship with Melissa?
Yes, ma'am.
And was she able to tell you about Melissa's feelings towards her brother?
She shared that, yes, she was.
What would she tell you?
She shared that they had problems as a couple, like everyone else. Sometimes they had problems.
Did Melissa ever tell you did Kimberly ever tell you if Melissa was planning on leaving her brother?
Yes, ma'am, she did.
What did she say?
She said that we were speaking, and she indicated that in a conversation that she had with Melissa, Melissa expressed her love for her brother, but while she loved her brother, that she was planning on leaving him.
And did Kimberly ever indicate that Melissa wrote her a letter?
Yes, ma'am, she did.
Did she still have the letter?
I don't know. I asked her about when we were doing the interview details if this was based on something from the letter, so I don't know where the letter may be.
And after speaking with her on the telephone, did you have the occasion to try to meet with her in person?
Yes, and I'll say that the telephone conversation was, the purpose of that was to set up a time that we could come meet, and I can interview her more in detail.
And did you eventually meet with her?
Yes, ma'am, I did.
And when did you meet with her?
Well, that was April 23rd.
And when you met with her, was there anyone else present with her?
Yes, ma'am, there was.
Who was present?
Her mother, Kathy Wolfenbarger.
And during that meeting, were you able to speak with Kimberly by herself?
No, ma'am.
Why not?
When I got there, of course, I met Kimberly, and I saw that Mrs. Wolfenbarger was there and learned who she was. And I told her that I would like to speak with Miss Kathy as well, but it was my intention to interview her, Kim, and then speak with her mother. And that I would like it nice if her mother was to be able to leave. But Kathy made it very clear, I should say, that she was not going to leave. She was going to stay there with her daughter at the interview. So at that point, I had no other choice but to interview them together.
And where did you go to conduct the interview?
I went to Kim's home.
So this is at Kim's house?
This was at her house, yes, ma'am.
All right. I have no further questions.
Mr. McDermott?
Mr. Calhoun, you interviewed a lot of people during this investigation around that time, correct?
Yes, sir.
You interviewed Christopher, didn't you?
Yes, sir, I did.
And you remember making an audio
Yes,
version of that interview?
yes,
Do you remember interviewing Don Perone,
yes,
the neighbor down the street?
yes.
You remember Don telling you he drives a hearse?
Objection, hearsay.
Sustained.
You made an audio recording of that interview, correct?
Yes,
And you interviewed several other people. You made audio interviews of them.
yes.
And we have something like 6 audio files that you created.
I'm not sure the number.
Does that sound roughly correct?
That sounds like that.
Okay. And for this discussion with Ms. Cameron, did you audio record that?
Which the initial phone interview,
The one you just testified about right here?
I believe I did. I'm not sure. All the interviews were there. If I recorded an interview, it was in the file, but there were some times where I just wrote things down from my notes.
So if there's no audio in the file, then you didn't do one.
There was no recorded interview. I just went on the notes from that interview. Yes, sir.
So what you testifying here today from the notes you wrote?
Excuse me?
Are you testifying here today from the notes you took on that interview?
Yes. And when I say notes, the notes that I did, the way it happened is, as investigators do, we have notes, a notepad, and you'll just write notes throughout, the course of the investigation. I then at some time take those notes and transcribe those to the report.
Okay. You mind if I see your?
Yes. Those would be the 2 pages from that time frame.
So those are not recording anyone's exact words, correct?
No, I just gave a brief synopsis. If you read these notes, you'll see this is just a synopsis of what they said to me.
Okay. And we have no way to check to verify if that's what she actually said.
What's that? Who's that? I'm not sure who you're talking
But you
about.
interviewed Kimberly, correct?
Yes.
And all we have from that interview is your written notes on it.
Yes,
So we have no way to verify that that's what she actually said to you.
I guess that would be correct.
Okay. No further questions.
Ms. Hilton?
Did you have any reason to make up what your conversation was with Miss Kimberly Cameron?
No, ma'am. This was something that I had no reason to make anything up.
Thank you. No further questions.
Mr. McDermott?
No further questions.
Okay, thank you, sir. You may step down.
Thank you, ma'am.
Ms. Hilton, state my call next witness.
Yes, Your Honor. State calls Andre Curitan to the stand.
Thank you, sir. Do me a favor, come to the witness stand. When you reach the witness stand, before you have a seat, if you'll turn and face the deputy and raise your right hand, tell us where you in. Yes? Swear in the witness.
You swear to affirm the testimony that you're about to give the truth, the whole truth, and nothing but the truth. So you may have seen. Please state and spell your full name for the court, please.
First name is Andre, Andre. Last name is Cureton, Cureton.
And where do you work?
Fulton County District Attorney's Office.
And what do you do for the Fulton County District Attorney's Office?
I'm a senior investigator.
And just describe briefly some of your job duties as a senior investigator.
We mostly we're assigned to attorneys. Anything they need, any evidence to be picked up, we subpoena witnesses and sit with our attorneys as they interview the victims or witnesses.
And are you also required to sit in the trial of those attorneys as a trial may proceed?
Yes.
And have you been sitting in this courtroom for the duration of this trial as it's been proceeding?
Yes.
Right. Now, as a part of your responsibility, you said that you have to meet with witnesses with the attorneys.
Yes.
Do you recall ever meeting with a Norma Patton?
Yes.
Okay. And when you met with Norma Patton, do you recall her ever providing to the state letters and cards?
Yes.
What is the category of those letters and cards that she provided?
She provided to them. No, we made copies of them. When legal assistants made copies of them, so we have.
And so did she bring originals and the legal assistant would always make copies of the originals?
Yes.
And it will show you what's been admitted 67, 68, 69, 70, and 71. Are these some of the letters and cards that Ms. Patton provided that you make copies?
Yes, these are some of the ones she brought in.
And then we make copies.
Yes.
Thank you very much.
Mr. McDermott?
I have no questions for the witness, Your Honor.
Okay, thank you, sir. You may sit down.
Thank you.
Ms. Hilton, state may call next witness.
Your Honor, stay no further witnesses. Stay rest.
Mr. McDermott?
No further witness, Your Honor.
Okay, so that means the evidence in this case is closed. Ladies and gentlemen, there are a few things that we have to take up to get ready for closing arguments and the final jury instruction before you begin your deliberations. And so it's about 10:20. I'm going to excuse you. I'm guessing conservatively about 20 minutes. I'm hopeful that we'll be back in here around 11 just to give you a target for what to aim for. But for now, you are excused. We'll have you back as quick as possible. Thank you.
All right, well, you're.
You may be seated. I'm not going to give the prior difficulties charge. That, as I consider it legally, I think there is a conflict in, I cannot find case law. If you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case, then I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, it's considered, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine that a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that I don't believe that there are facts from which the state could present the count 2 felony murder requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder. We also need a redacted indictment reflecting only that one count of felony murder. what record would anybody like to make regarding that ruling? Mr. Wilson, you're standing.
I would, Your Honor. And
Yes, sir.
I'd like you to reconsider it in light of, I did look for some case law, and I thought what was would be very helpful to everybody is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition. And what I found was Richardson versus State, and the site on that is 278 Georgia 548, and it says that if there is evidence of an act, the jury can, and remember, we're dealing with the standards for directed verdict, whether there's a reasonable path or a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294 GA 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence, and that's what we had from Dr. Terry.
Right.
And that was acceptable, and I believe, and that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick, Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before, he'll do it to her, he can do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on the cycle of violence and what happens. Your Honor, there is a path, and I understand where the court's coming from. But I think when you allow intrinsic evidence that can be used for any purpose, that's what the question is on a directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault, and this is why she died. And that would bring it in directly with the case law. So that's our argument. Your Honor, I think the court should reconsider its motion, or its ruling on the motion, and allow this case to go to the jury, because I think there is evidence. And I know the court is struggling with that extra evidence, but it's there.
A couple of questions. One, I was able to pull up the Courier case. I'm not, the first case you gave me, I don't know if I typed it in wrong or wrote it down wrong. Can you give me that site again?
Sure can. It's 276.
Wait, say it again?
276.
276.
That's what, I think we all wrote down 278, or at least that's what I wrote down. 276 Georgia 548.
Yes, ma'am.
Thank you. I will tell you, one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered in a decomposed state, which is evidence from which a jury could find that aggravated assault of which there was evidence caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
Well, and I think when you, like I said, when you allow intrinsic evidence, is there a path? That's the thing. Is there a path for a reasonable jury to conclude that the violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not really the relevant factor. It's is there evidence? And I think Richardson talks at that, and I think Courier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to, and given the standards on a directed verdict, could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma. That's, again, factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts. from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred. And so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your
Anything
Honor, I'd
further?
also point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40. What I need to do is I'm going to, as I said, edit the verdict form. I'm going to email y'all in just a moment. I'll probably have my staff print a final, or more final, unless y'all tell me there's something else to address, version of the jury charges. Is the state in a position, because y'all have, my understanding is it's easier for y'all to print a version that's whited out of this. I can have my staff get rid of count 2 in both places if you want me to, but since the indictment goes back with the jury, they need a clean version of it, which is that one count. Okay? Okay. It is 10:40. My goal is to be back in here at 11 with everyone's final approval of the verdict form and the jury charge, and then ready to start with closing arguments. Is that good with everybody? Mr. Fawcett?
Yes,
Mr. McDermott?
Yes, Your Honor.
Okay, we're in recess until 11. Focus on the closing arguments and the jury charge when I get it to the jury, and so I'll ask that you not go in and out, and if you absolutely have to go out, if you'll please do so as quietly and non-disruptively as possible. Thank you.
Here we go with closing arguments.
Please be seated. Ladies and gentlemen, I'm now going to allow the parties, the state specifically, to make its closing argument.
Thank you. So what's being depicted now is one of the first exhibits that we introduced. That is a photograph of Melissa John Wolfenbarger. That's a photograph that was taken somewhere around 1997, a year before Melissa went missing. In 1998. We know that in 1998 she was 21 years of age. So she's roughly about 20 years old at that point. And even though she hadn't gotten a chance to live a very long life, she was a mother at that point. She was a wife. And when I look at, when I see that photograph, I see a smile, but I also see hope. I see hope when I look at that photograph because of what she must have thought about her children, what she hoped for them, the life that she hoped to live. And I think about the 27 years that has passed and how long that is to wait for justice. So that 27 years, that's a long time to experience life. That's a long time to fall down and get up, and fall down and get up. That's time to experience and have memories with your children. Children that don't have a memory of Melissa, not Joseph, not Christina. That's an opportunity to have and create memories with your grandchildren. That's 3 grandchildren that you heard Christina testify. She's got 3 boys. There's opportunities. That's what was missing. That's what has been missed. That is what has been taken away from us. The opportunity to have those experiences. And she deserved that. Even if she didn't want to stand with this thing. Even if she wanted to leave him, she still deserved to have that opportunity. She was manipulated. She was intimidated. She was abused. And she was coerced to give up her children. I believe that's what the evidence shows. I can tell you, 27 years later, I would not expect a judge
allow a defendant that married his wife to be alone with them, to speak to them 6 days after it happened. Roughly 5 or 6 days after they went down to apply for a protective order. 5 or 6 days after the order, and just let her speak alone with him. And then on that very same day, I want to dismiss. On that very same day, children go back with mom. And we don't know what was said. We don't know what was said. We don't know what he said to them. We don't even know if the bruises that were on her from his attack on July 21st, 1990, we don't even know those that fully healed. I can assure you the victim has most trauma from that act. Having to call the police. After a period of time in July, we know she had already been abused and experienced abuse. So when we think about domestic violence and we think about being intimidated, coerced, that's what I want you to think about when we look back at that day July 29th. I believe definitely shows that she was intimidated. She was able to be coerced, especially after being beat for a year by this defendant. And I don't believe that she ever intended to give up her children and walk away from her family and her
Your
children.
Honor, I want to object to the counsel's repeated use of "I believe," "I can assure you." Counsel is not supposed to interject personal opinion.
Understood. Mr. Fossett has offered to rephrase. Go ahead.
Now, the indictment you'll be able to have one count of murder, malice, murder, the intent to kill. The intention to kill was done one part. And this is why we're here, from what was found on April 29th, 1999, and June 3rd, 1999. Goal of Mr. Wolfenbarger, his job, is within that same vicinity, a minute from the residence where Christopher Wolfenbarger and Mr. Wolfenbarger live. And your judge is going to instruct you that you are duty bound to follow the law, and in your consideration of the law, you should consider certain things and certain things you should not consider, such as sympathy for either the victim in this case or the defendant, disagreement with the law, conjecture, dislike of the system, television, public opinion, penalty, or punishment. The only thing that you are to decide when you're considering evidence is whether or not the statement met its burden beyond a reasonable doubt and prove the guilt for innocence of the guilt of this defendant. You should consider the elements of the crime the law which the judge will give you, the oath that you've taken as yours, if that's the case, as presented in the form of testimony, video exhibits such as the video of the defendant hiding, audio exhibits such as the audio of the defendant stating that he had looked for her, acknowledging that he took assault, also acknowledging that she was dating someone and seeing someone and staying with someone they might. You also consider credibility of witnesses. What was it like in your testimony? How did he answer questions? You are entitled, you're the determinant of the credibility of not just the state's witnesses, but also the witnesses that the defendant called. Y'all consider what the defense is. Now, the defendant doesn't have to present any defense. Walk in court Tuesday, Wednesday, say, hey, make improvement. But that's not what happened in this case. Defense in this case is called back. Listen to the theory, open statement. Defense in this case is called back and killed Lewis Walker. Other than the fact that evidence came in and called back and did murders, what other piece of evidence or fact, anything that you heard during the course of this week, what points to that? What other fact will allow you to create that evidence? Other than the fact evidence came in, Melissa didn't even know about it. The only thing that's come in about the relationship between the Pattons and their children is that they appear to love each other. It's not so unbelievable. Based off of the letters that Melissa wrote, cards that she wrote, times that she wanted to take her father, Carl, and her mother going out for lunch. Those are going to be back in the room if you observe it and look at why you deliberate. This case is just simply not about Carl Patton as much as they want it to be. This case is about domestic violence. This case is about intimidation. This case is about loss of control. The loss of the defendant had over custody of his children and over Melissa. No matter how much they want this case to be about Carl Patton, this case has nothing to do with Carl Patton, other than the fact that he asked law enforcement to find his daughter. Why does Norma go to the residence of Kathy Wolfenbarger looking for Melissa, raising attention to that issue they're responsible for? Now, a lot of facts that come to evidence in this case, I would ask you to put weight on more facts that have been corroborated, like that. You heard that from Norma. You don't have to just take Norma's word for it, because you heard that from Christina. She does not have a lot of memory from her childhood. She doesn't have memory of her mother, but she remembers that day. But that stood out. Where's my daughter? I can just imagine how that was. It wasn't a calm statement. It was screaming. Where's my daughter? Norma probably showed up at that residence, Kathy, in a panic. Where's my daughter? That's something that Christina would remember. And that's why you should believe that happened. And that's why that theory is just plain ridiculous. Most importantly, common sense is the main thing that we're asking you to use inside of this case. What does the evidence tell you what the facts are? What's been presented? Judge is also going to charge you on what reasonable doubt is and what it is. Just going to charge you that the state is not required to prove the doubt or the guilt of the defendant beyond all doubt for mathematical certainty. Reasonable doubt is doubt with fair-minded and impartial juror, honestly seeking truth. It is doubt based on common sense and reason. It is not meaning based or arbitrary doubt, like Carl Patton. They arbitrary, not supported by the facts. Thrown out, hoping to stick on the wall. Evidence may be direct or circumstantial, or both. Consider the evidence you may use your reasoning and common sense to make deductions and reach conclusions. May be direct or circumstantial. Direct evidence is that which may be seen or heard. Otherwise, direct in sense. So when Christina says, I saw Norma show up to the residence in a panic looking for her daughter, that's direct evidence of her observations. And from that recollection, the testimony of Norma, you can infer that Norma was sincere when she was looking for her daughter. The types of inferences you can infer from the facts that were presented. And then we have the circumstantial evidence. This is exactly what I was referring to. We got direct evidence of tool marks on bones that were recovered and identified as the remains of Melissa Wolfenbarger. Tool marks are direct evidence. Those observations, you'll have those that you will be able to review and look at while you deliberate. We also have direct evidence of the defendant's possession of assault. Two separate facts. Now you wouldn't, and we wouldn't walk into court on Wednesday and ask you to convict after tool marks on the bones and remains of Melissa Wolfenbarger. And we wouldn't ask you to walk in here on Wednesday when we start presenting evidence to convict this defendant of murder because he was in possession of assault. And you draw logical, common sense conclusions. That's just one piece of the evidence that has been presented, but you were able to do that. We got assault around the same time that the wife was missing, the wife's remains were located. Medical examiner says there's Exhibit 66. It's consistent with the type of marks that he made by that agent. And in his own statement that he was in possession of it around that time, and in the statement of the rocks, although they were reluctant to say so, that they never got that saw back. We would not ask you to convict solely based on that fact alone, but that is a fact that you can consider, and those are inferences that you can draw. Reasonable, common sense inferences. So this is what I saw when I woke up this morning. I probably see this a lot more than most people, but when I woke up, this is what I saw. And I had time, so I stopped by to get some gas. And by the time I finished, I got back and I cranked up the car, and I'm back on forward. I never saw anything going to my vehicle, but during that period, I smelled what appeared to be gas because I cut grass. I smelled gas. There's less money in my account. The numbers on the dial, I hear a clicking sound, and so even though I never saw any gas on my vehicle, there are logical deductions and conclusions that I draw from all those facts and circumstances. Nobody's going to be able to come and tell me that Santa Claus put gas in the vehicle. So when we ask you to use your common sense and look at the facts, the evidence is what it says. The facts are what they are. In the count of murder, you'll get the indictment. You'll see that it's charged that the defendant was now supported cause the death of Melissa Wolfenbarger by inflicting homicidal violence. Now, as it's charged, that term homicidal violence, based on the manner in which the remains were recovered, it is impossible for another examiner to determine if she was shot, if she was strangled, if she was stabbed, any number of ways that you could commit a murder could have been committed to Melissa Wolfenbarger. But you can't tell if someone has been strangled if the neck is missing. You can't tell if they're stabbed or shot in the torso if there's no torso. And what we're able to determine based on the testimony of the medical examiner is that the facts and circumstances which she observed is how the remains were located, the history, evidence of domestic violence in that relationship. The fact there's evidence that someone removed her limbs with salt. All of those facts, and the fact that her testimony, her medical examiner expert, she did not believe that Melissa Wolfenbarger died of natural causes. All those are facts that point to homicidal violence. Her opinion was that it was more likely that Melissa Wolfenbarger died from homicide. That was her opinion. And that's why the indictment is charged like that, is because of how she was found. But that does not take away from what we have proven based on the testimony. And that is that she died from murder. That is called homicide. There's no charging of law of malice. It's not ill or hatred. It's just simply a killing without justification, excuse, or mitigation. It can be expressed, never intention to unlawfully take a life of another person. It may be implied, but no considerable provocation appears in all the circumstances clearly show an abandoned and malignant heart. I submit to you facts and circumstances of this case, and all the facts and circumstances of this case point to that conclusion as the only reasonable conclusion that this defendant did in fact commit malice murder on the person of Melissa Wolfenbarger. state does not have to prove premeditation to prove murder. Regardless of how briefly that malicious intent existed, malice may be formed in an instant. And if malice was in the defendant's mind at the time of the killing or act, and prove the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive is for use in determining the defendant's state of mind at the time of killing. You are allowed to consider it, such as the evidence of domestic violence is lawful evidence of motive. Did he abuse her that year? Did he hit her? Did it happen multiple times that year? That's what the facts are showing. You can use that and those facts and the expert testimony from the domestic violence experts as evidence of the defendant's motive. And all of those things I previously mentioned, the fact that over criminal case that she wasn't able to appear to. The fact she was seeing someone else. In fact, I don't believe it, that she had continually left it throughout that year. All of that is evidence of motive. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. There's no legal requirement of corroboration of witness, provided you find the evidence to be sufficient. That means if when you heard the testimony of Christine and you believed it, you don't need any corroboration to it. But that to be a fact that you consider. That means if you heard the testimony of Christina and you believed her when she said this defendant, we always talk about going to run. When we talk about, you know, how to give her advice, who says that to his daughter, considering how her mother was found. But that's after she says that after. Melissa Wolfenbarger's remains have been identified. He makes those statements. That's what she remembers growing up. Does that? This defendant. This case went through several detectives. They basically continued to work on this case. Detective Calhoun and Detective Shepard. Even through the retirement of Detective Calhoun, they continued to work with Detective Shepard until the cold case unit was created. And then 3 years later, you have this indictment. So from Detective Kelly, when we're talking about this skull is found, to the point where Norma Patton goes to Henry County, and Detective Scott really is the first investigator that starts to really investigate and look for Melissa as a missing person in Henry County. He wasn't able to get a lot of traction with the Atlanta Police Department at that point in '99. We have Detective Scott, who interviews the defendant. Back during that period, it's before 2003, he says, March, April, '99, last time he saw her alive. You have Detective Calhoun being assigned to the case in 2003 when her remains are identified. And when he retires, you have Detective Shepard, and he works with Stein to do some additional testing. And Detective Scott testified that he was one of the first persons to begin the missing persons investigation. And that's when the defendant, when he interviewed, told him that last time he saw Melissa was in March of '99. And we know that from the subsequent statement in 2021, when he met with Detective Shepard, that's not exactly what he said. He says it was around December of 1998. The only difference between when he makes that statement before 2003, that he saw her in '99 in March, and in 2021 is Melissa's remains have been identified. We know that the remains were located right by his job. And I submit to you that there's a reason why those two statements are consistent. That's mine. Once the remains were identified, to say that the defendant's remains were identified, and also began to look into the history. The first thing they do in homicide investigations, they look at what was the victim's life like. First thing he saw was there's evidence of domestic violence. And what also stood out is the location of where Melissa's remains were found. We know that from the testimony of Melissa and Chris, the defendant lived in this area by Wolfenbarger Street. We know that Ashley Lass is right here. And here's the junkyard. So we know that the head was across the street from Ashley Lass. And we know that the extremities are virtually right next door to Ashley Lass in this wooded area. So make no mistake, everyone's a suspect, but at this point, all of the evidence is pointing in this direction, this defendant. What is the evidence against this defendant? So there's a timeline of abuse in this case that's presented. We'll go back to the beginning of '98, the testimony of China Patton that Melissa started working with her. It was Virginia Highland Waffle House somewhere around the end of '97. So they're working together sometimes on the same shift at the beginning of '98. And at one point when China remembered seeing marks around the neck of Melissa Waffle. What she described appeared to show marks of someone's hand around Melissa's neck. Immediately, What was this defendant went out to the front? And that's when he got into the altercation with Troy Clinton. That's what you heard in the testimony team. And that's the beginning of 1998. We get to July of 98. And so this is what Detective Calvin is looking at as he's beginning to investigate the case. He's looking at the location of remains and where he lived at, his job, and he's looking at all this information. All the evidence is pointing at this defendant. There's a police report that's created where the officer observes bruising and marks on the person who was Wolfenbarger, Melissa. After that, he directs her, the defendant is there. He doesn't wait around. After that, he directs her to go for him, take out a protective order, get you some protection from him. And that's exactly what she did. She went down there in person and applied for a protective order. So those are the records that Detective Calvin had access to. This is the day after that July incident, July 21st. So the next day, July 22nd, she goes to the courthouse and petitioner seeking relief from family violence. From him. That's what she was seeking relief from. She was seeking relief from the choking that she had, and her sister was her, that Troy talking about. And we had that Rule 9 side setting down for the 29th, and then we have that where the judge allows her to speak with this defendant. Just days after that. Days after her hair being dragged, days after she's been hit. And then it happens. It wasn't just what China said. It wasn't just what Marlon Sutton said about what he observed. There's another person who saw that abuse. Dorothy. Jones, Cooley Jones. Dorothy Cooley. She lived in that area. She actually known the defendant before she met Melissa. And remember seeing a day where Melissa had shades on and a black eye. When we talk about testimony of the domestic violence expert about humiliation, isn't that really walking around with yet another bruise, another mark, another scratch? Sitting up here talking about skin conditions. That's not skin condition, that's a black eye. You should be offended by talking about skin conditions and trying to pawn that off as a reason why people saw marks on her. You didn't see a skin condition, these marks from this defendant's hand around her neck. That wasn't a skin condition. That was bruising for being choked. The black eye was a skin condition. You punched her in the eye. It's not a skin condition. Thomas Dixon. All the witness statements line up perfectly on top of each other. The witnesses that observed the abuse during this is the interview. So we go from 10 at the beginning of 1998. We go from Dorothy. We go to July. Officer 7. Then we get to the end of 98, and she's still getting abused because she's still going back and forth between Dixon and this defendant. She's still talking about the abuse. This is at the end of the year. Last time he sees her, she's being whooped, intimidated, coerced, bruised, punched, dragged down the street the entire year of 98. And I submit to you, that's not the first year it started. It didn't just start in 98. Even further, this has been going on for a while. Not just 98. Dixon confronted the defendant after he came to the White House at the end of that year. You gotta leave. You gotta go. What did Dixon see? Them talking, Melissa crying. Kind of like that July 29th day courthouse. Them talking, Melissa crying. Then we got investigator over here. You heard testimony that from the mother. The DA's office went to interview the defendant's sister a year before that act. He knew from that the DA's office was still conducting an active investigation into the death, murder, disappearance of his missing murdered wife. So make no mistake about it. That had already happened a year before. He knows exactly what's at the front of his house. Oh shit, it's his thing. He's hiding for 30, 40 minutes. Come out. He's right here. Let's see the video. There he is. Come on out, buddy. Gig is up. He had 27 years. It's up. Hiding. And doesn't it look like what you saw? Doesn't it look like it was playing? It didn't look like it was his own. No. It looked like he planned to go there. Got there real quick, went out there, inside out there for, I don't know, 10, 15 minutes. It's police. Go hide. Guilty. Check. He picked up this investigation. those same suspicions. Calhoun had. All the evidence is pointing to this defendant. But, I'm gonna do Chris. See what he has to say. Let me see if this thing is inconsistent. Well, he admits to being fired because he thought his door was off. That's interesting. Did any part of it? That's interesting. He admitted that him and Melissa were having problems. He admitted that Melissa was seeing and staying with a guy named Mike. Admitted that he did not look for his wife. Well, here's the thing. Even if he still has 2 young children, very young children. Even if him and Melissa had planned on going their separate ways, wouldn't you think that at some point he'd want to be able to tell his children that he looked for their mother? When you think that? When you think at some point, for his children's sake, he would have tried to look for their mother? That is a fact I think you should consider, because you look at all those pictures of Six Flags. What are you trying to say? He's good father? No, he's not. He looked at their mother. You can take your kids to Six Flags every day and not take away from the fact that she didn't do what she was supposed to do. One, you should have abused her. You should have hit her. You should have punched her. You should have grabbed her and dragged her. You should have murdered her. That's not a good father. And then you have that statement they made to the detective. Detective Shepard, and I want you to hear this. So I'm going to take a moment to play it. I want you to hear this. What he says, those points in particular, what he says about assault, what he says about his efforts with his wife, and what he says about his knowledge that she was going to leave him, the problems that they were having, and the knowledge that she had about these things. I mean, before that, I mean, where was she working? At that time? The wall. I mean, like, what that was, no, all right, so when was the last time you saw her? And that's the thing, I don't quite remember. The last time was, I remember when she was coming and go, okay? And we say that it wasn't like, we're happy to go, but she's sitting out here one day and that she was up and gone. I don't know if that's the way. So you kind of, would you describe your relationship as tumultuous or like on again, off again? It was rocky there towards the end, mainly I think because it was her family so far trying to get back in her head and trying to make her think things and do things. And like what? She never had a relationship with her sister at all. And then towards the end, everybody has a need for one, family was the one type of thing. And I think there's where maybe she tried a little to try to get back with them or do what. But I don't think it was near what they made it seem like, that she was there all the time, she was in the car, pictures. And I know that did happen sometimes, she did, at that time, but the trouble that we had a common goal of what we were trying to accomplish. We had several of our, which was to go to California. This is, she was able to get that home. She was home with my mom. She didn't want one to happen. She didn't want her to be ready, but she wasn't there. There was no, we knew that her hands were bad, and anybody sitting out there didn't do it. Okay, so when was the last time you saw her? So the last actual time I remember was like, I woke up and she was gone. Like, we were another night and she left. And I don't know if that was the last time. The last time was when I dropped her off the train station to work. It was exact. Do you remember telling Detective Calhoun that the last time you saw her, you were driving up to your house on Brookline and saw her walking down the street? And that was the last time you saw her. I don't remember saying that, but it's possible. Okay. I just don't. So that, basically, you said that was the last time you saw her, and she said she was going to the train station. Something to that effect. I'm not saying verbatim that's what you said, but it was something along those lines. But does that sound like it's accurate? I don't know. Do you remember that incident, or do you recall that happening almost about the home driving up and her walking down the road? Is that ringing bells? I mean, that's usually what happened because they only had one road. If there was walk to the train station, try to go to work or something. Or get a ride, or sometimes she just wouldn't walk. Like I said, we're talking about everything far away. We're talking about people at the end of the road right now. Yeah, I don't think there is it. But talking about that specifically, do you remember that day specifically? I don't know. Well, I would like to ask you, what was she wearing? Do you remember? Did she have a purse with her? I don't know. So you don't, the last time you saw her, when you came back home, she wasn't there. Where was her stuff? She didn't have a car. She couldn't move. So you're still there in the house? I mean, if she left, it's just like that. There was only like a small
I mean, kind of the same thing I did. I mean, when Austin Valley moved, my grandparents was going to sell the house and everything. You know, when I left, I didn't think hard nothing. I went to live in Austin, whatever little.
After the last time I saw her, for that, when she left, did she tell her family? Did she tell your family? Did you tell her that you like her?
I mean, she left many times before that. When she was leaving, I never knew that was the last time I was going to sit here. If I did, I would have, you know, freaking kept her there.
After like a month or two, you could think that was.
You know, after a while, I was thinking that she split and moved on. I mean, there was, you know, she was maybe seeing the guy and everything that was up there, or I know that she was living with in Hoover, or no, I can't remember the last one.
Was she seeing somebody?
I don't know if she was seeing somebody, but there was this dude, and I want to say his girlfriend, that sometimes that she would stay with him in like in a tiny lodge out that way.
And how did she know this?
She worked with him.
Was it the girl or the guy?
I want to say the guy and the girl both worked there, but I could be wrong. I know the guy worked there, but I know that it was a couple, you know, because then there was this one time that they had called me and said that they were moving and she had to go to do something. You know, she had to do something else.
This was before the last time you saw her, right?
Well, that's
That's what I'm saying. I'm just wondering.
all that was
I'm not misunderstanding you. I'm not trying to trick you or confuse you.
No, I just want you to remember. Hey, I'm trying to figure it out.
Like, if you were there, I was. So that's fine. I'll tell you about it. Just want you to be accurate. All right, so year goes by. You said, oh, don't tell anybody that you don't.
I mean, I'm figuring that she's already done. I mean, we were always talking about changing things, and you know, she had the stuff there.
Right.
You know, and she got to the point where she was happy, unhappy with me. I'm not trying to push myself in anybody's life that doesn't want me there. And I look at my daughter, and everything's going there. I try to push. And you know, looking back at everything now, I was wrong. All the way around with both of them. Maybe I should try to push forward, try to do it with.
You said you lost your job, right, man? Your job, the last time you wanted to lose your job.
Man, this guy, now, there's a lot of things going on right there with that. But, and I do now the same thing pretty much I did then. I mean, I work on Wolfenbarger and things on side. And there was a guy that I know he stole things. There was a saw that was missing. And I can tell you that guy that I borrowed this tool from and everything, I didn't steal that saw. Period.
Why did I?
Because he said I stole the saw. Because the saw was missing. And I lived around the corner and he drove past my house and he seen back the Wolfenbarger at the top, which was put off.
So you thought you had something off the car.
You know, and I thought, look, I don't know anything about it. You know, and then there was that, and then there was something where I drove through the Cold Plaza thing on 400. You know, there was just a bunch of little things that was just last right.
Why did you go to the Cold Plaza?
You know, there's just a thing where you go and follow through it.
Right.
You know, and I was under the understanding, I was under understanding that, you know, there's things changing, or just one little thing. And that was like, there was no deal, there was no. Right.
Dead body, so.
Yeah. Well, we had to do it, and, you know, if it comes everywhere, I've always thought, I was terrible there, but I did the last job.
Did you ever go to the Waffle House and get an altercation with mail?
I don't remember, I saw that on the internet, I don't remember that.
You guys came up there and beat you up.
And it seems like I would remember that, but I don't, you know.
You drive the yellow Volkswagen?
I never had yellow. What?
You never yelled at
Never, I never, I had a thing against yellow cars.
What do you think happened?
Man, here's which way I think about it. It has to go back. If her parents didn't do it directly, it had to be something indirectly around. I'd be wondering.
So when you found out that a body was found just around the corner from where you were, and the body had been dismembered with a saw.
I didn't know that the body was dismembered with a saw at all.
You know the body was dismembered?
I heard that. Nobody ever said so. I didn't hear about that. Nobody ever gave it. I don't know about said that to me. I didn't know that until from the hearing. Honest to God.
So what motive would her family have?
I mean, to me, it sounds strange that they got away with this stuff for all these years, and then all of a sudden, right, as we put up the right here, all of a sudden she ended up guilty. I don't know if she came to them with money, or.
Do you think it's likely that her own family murdered her?
Man, her own family killed her family and friends.
Yeah, I know he's been murdered.
So his family and friends.
Why would he kill her? What would be the motive?
Hey, man,
He's involved in, your family's involved in criminality, and you're trying to protect yourself from going to jail.
nobody coming after you, I mean, you just tell the own daughter. Oh, they come after me, I didn't do anything. I didn't come in, here's what I'm saying, okay? I don't know if she needed money, or they come in and trade them some kind of way, and, you know, and they get, whether they're drunk, it's one thing that I don't know, but anything I say at this point is speculation, because I don't know. But I feel like the hell, if they're serial killers, they have killed their family and friends, and something happens to their family. Okay, first of all, serial killers, obviously. Okay, let's say this, okay? Well, I'm not here to talk about, I'll deal with their family. Right. Where's the facts? Facts, you said that she was put in bags, right? What's in the internet that she was in a lot? I didn't say that. What you put in there? We're being traded. I'm trying to understand, what I understand, the body parts had washed out of an area onto the street. Now, there were bags recovered there, so if you make the assumption that they may have been back, yeah. But I don't, I wasn't there, so I can't. Nobody has been traded with me on this, okay? And then everything that I'm learning is basically through the internet. So we all know how the internet lies, and a whole, I agree with 100%. Everything that the internet says about me, even though they're different names, trying to hide their family lies. And that's why I'm asking about that, because I'm not going to go off on speculation from the internet. Throughout the trial, you heard from the testimony of Dr. Rosa James. She was a domestic violence expert. She had hundreds of experiences with persons that have been victims and perpetrators of domestic violence. She was able to tell you about some of the cycles of abuse, talking about the tensions building. At the beginning of 1998, we talked about the incident, different phases where there's an incident, then there's a reconciliation, and then there's calm. And so ultimately, what we have from the beginning of 1998, when Melissa started working with her sister, we have a representation of what that expert was talking about. We have the tensions, we have the incident, we have the reconciliation, I'll call that last night, and then we have the subsequent calm until we have the experience of Melissa. And I would submit to you that testimony of the expert, of Dr. James, is relevant testimony, is testimony you can and should consider in evaluating what's been presented in evidence of domestic violence. And I would ask you to put the appropriate weight on her testimony and use that in your determination. Dr. Mark Gilbo is an anthropologist with a specialization in skeletal remains and analysis of skeletal remains. He was able to say he observed soul marks on the remains of Melissa Wolfenbarger. And as far as the exhibits that he was able to go over, exhibit 34, which you'll have, you see the example here where he's talking about part of the bone that has been shaved down. And you have next exhibit, the autopsy of the remains of Melissa Wolfenbarger. You see where the saw marks are that were indicated by Dr. Gilbo, what he observed. And then you have the bridges here, where it also appears that there's some type of mechanical saw or device that is being used to dismember the remains of Melissa Wolfenbarger. I'll submit to you those are facts and evidence along with the fact that this defendant was in possession of the saw, the fact that this defendant borrowed the saw from his job, the fact that this job never got the saw back. Those are all facts to be considered. Those are all logical, common sense deductions. And then the testimony of Dr. Cherry. You heard about the analysis and testing, in particular the swabbing of Norma's mouth, the analysis of the dental records, and that ties directly into the additional analysis and test that Detective Stein did, and he academic Detective Cherry. And we have that additional testing where, even though it didn't result in any useful, Detective Stein was able to retrieve the bags and submit them for additional testing. And I submit to you that those bags were outside for who knows how long. I submit to you that there was evidence that the head had been moved. I submit to you that George McEachran encountered that bag along with his daughter. I submit to you that Tina Miller, Wolf County Medical Examiner's Office, responded to that location along with Detective Kelly and the Atlanta Police Department. And even though that did not result in useful information, the process is important because it's important to cross every T and dot every I. And in this investigation, that's a part of the process, and that's what we do. And at this point, ladies and gentlemen, I'm going to sit down. The defense will have to address you with your arguments. I will submit to you that this case is not about the family of Melissa Wolfenbarger. This case is about the tumultuous relationship between this defendant and our victim, Melissa. He wasn't able to control her, and when he lost control, he murdered her. That's what the evidence is showing. And at the conclusion of the case, after the judge charges you on the law, when I ask you to quote the truth, and that's guilty on that count of murder. Mrs. Knight.
Thank you. Mr. McDermott, does the defense wish to make a closing statement?
Yes,
Closing
Your Honor.
argument? Thank you.
Just a short word about how this works. The state gets to split their argument. So they'll make an argument, I get to make an argument, they get the last word too. Okay, first word, last word, and I don't get to rebut that. That's just the way it is. We accept that. You've all taken an oath, and you've taken an oath, and the judge will instruct you in just a minute. Not my words, not their words. The law that will require you to decide this case based on the evidence. Based on evidence. You remember in my opening statement, I told you that the state has got gaping holes in its case. And that the state is going to give you bits and pieces of evidence. And then it is going to tell you a story to fill those in the way that suits them. And it's going to ask you to imagine along with them that that story is true. And it's going to ask you to make a leap of logic at the end of it. From alleged instances of abuse to murder. And I have asked you to follow your oath, to follow the law, and decide the case based on the evidence, not on the imagination. Let's talk about the evidence a little bit. You've been told about the difference between direct evidence and circumstantial evidence. I won't rehearse the story, the lesson. What hard evidence exists in this case? I will submit to you that not one bit of direct evidence in this case points to that man right there. Not one. I'm not saying there's no direct evidence in this case. There's lots of it. There is obviously the remains. There is the manner in which those remains were recovered. We had the head discovered in the street on April 29th. We're not exactly sure how it got there. One detective thinks there was a great rain event that washed it out. Another one says there was a dog. We don't know. And then about a month later or so, they discovered several bags in the wooded lot behind the trucking business. Some people call it junkyard. Come back to that. The medical examiner eventually is able to identify the skull using dental records, dental charts, and notes that there are tool marks, of course, on the body parts. After some time goes by, we also know that there was a search of Christopher's former residence. There was lots of evidence taken from this. There was lots of evidence that came from the remains. As we talked about before, there were paint chips in the hair. There were human hairs, apparently not Melissa's. There were pubic hairs, a pubic hair. There was DNA evidence. There were carpet files. There's lots of evidence. And you heard the detectives sit there and tell you, we specifically sent this off for testing. Some of it more than once. Whoever's hair that was in there that wasn't Melissa's was also not his. Whoever's pubic hair that was also not his. Wherever those paint chips came from, it was not from his residence. Someone says, oh, it was remodeled. It may have been remodeled, but folks, when you paint over paint, the old paint's still under there. And you go scrape a paint sample, you're going to get all of it. None of it matched. There was luminol evidence. It sprayed the entire house, not a drop. And finally, the more modern DNA taken from the bag. You heard Detective Stein sit there and talk about the event where they went out with all the media to the site, looked at the proximity to where Christopher worked. You heard him testify about the DNA in the bag, and he read the results of those reports. Yes, we found DNA. Yes, there was a viable profile that represented 5 people. Two of whom at least were male. And they submitted Christopher's DNA sample. They went up specifically again to get new DNA from him and submit it for that test. That was in 2022 or so. Christopher willingly submitted. Yeah, he knew the DAs were still investigating him. He didn't run from it when they called him and said, hey, we'd like to get your DNA. And he submits it, and you heard the results of the test. Christopher Wolfenbarger is excluded from being contributed. Well, that's when we hear this theory about there was a great rain flood event. I gave this page from the weather reports. The National Climatic Data Center, the city of Atlanta, in April of 1999. I gave it to Detective Shepard, and you saw him pretend he couldn't. I believe it was done. I gave it to him. You saw him pretend, oh, I'm not comfortable reading this. This document's going to go back with you into evidence, and you all can look at it. And if there's a single one of you who can't figure it out, I will be shocked. The days go down here, the days of the month. The hours of the day go this way, and at the end, there's a cumulative total of the rainfall for each day. And you'll be able to look at this document and see that on that day, the other deputy who said there was an intermittent mist was correct. There was roughly 1/4 of an inch of rain for the entire day. And most of it appears to have fallen at about 3 o'clock in the morning, long before the head appeared on the road that day. And you can look up the rest of the way. 0, 0, 0, 0, 0, 0, 0, 0. Detective Shepard. Oh, it rained so much that month. No, it didn't. They analyzed the carpet fibers. They could find no match for this without. So then we're told about the circumstantial evidence. It's interesting to me that you just heard the district attorney tell you all the facts and evidence in this case point to one man. But he's not talking about this hard evidence, is he? Because there's a bunch of that, and not a single bit of it points to this man. All of it points away from this man. But Detective Shepard, or maybe it was Detective Calhoun, one of the two, got on the stand and said, there's only been one suspect in this case from day one. Well, when the results keep pointing away and pointing away and pointing away, maybe there should have been a different. Maybe you should have asked some more questions of the neighbors or the family. You heard the district attorney here tell you. That's how we conduct investigations. We look at the person's life. We want to find out what's going on in their life. They never investigated that family. They never investigated anybody else. Where are the records of the test of paint chips for a single other person's house? Where are the records for a search warrant from a single other individual's house? Where are the search warrants getting hair or pubic hair or DNA from anybody else in this investigation? Crickets. Because they want to tell you a story about domestic violence. I'm a supporter of Me Too. Domestic violence is a real thing. You've heard the district attorney tell you multiple times now, this is a case about domestic violence. It may have that question in it somehow. Certainly it does. It is an issue you're going to have to decide. You're going to have to decide how much weight to attribute to those alleged incidents. And you're going to have to decide, as a fact finder and determiner in this case, how it fits into the overall picture. But this is not a case about domestic violence. This is a case in which a man is charged with an act of murder. And the state has not given you one single instance or bit of evidence about an act of murder. gets you sympathetically on the board after he tells you, don't judge this by symptoms. But then he wants to tell you all these violent instances. He wants to embellish them. He punched her. That's not an evidence in the record. He beat her all the time for the whole year. That's not an evidence in the record. And they want to tell you that story and then ask you to make the leap to there must have been some act of murder also. What about these instances of domestic violence? We heard from first about the July 1998 incident. Yes, there's a police report. We had a police officer testify. He told you he did not look under her clothing. How could he have known if there were scrapes on her back or backside? He told you that. I didn't look at that. We get home and Norma says, well, I got home with her and she had scrapes all down her backside. Just after she had gotten done telling me that she was wearing blue jeans. I'm not sure how you get scrapes if you fall on the ground with blue jeans on. You have reports from Tina. Tina says she came in there with choke marks on her neck. And there was another guy named Clinton who stood up for her. None of that story is corroborated by anybody else anywhere. The only person who's ever told that story is Tina Patrick. Tina says she took Melissa back up to Chris's house on Brookline and confronted Christopher. But Christopher tells Detective Scott in his interview that he didn't like Melissa staying with her sister, because she got her into cigarettes and also was doing meth. Not necessarily that Melissa was doing it, but that he didn't like Melissa around that time. Well, I think there would be a confrontation when she brought her up there. We've heard from Mr. Dixon about domestic violence. It is funny to me. You should find it incredible that when he gives an interview in 2003 to the police about Melissa, he does not one time mention abuse, marks on her body, being drugged on the sidewalk, her complaining about her husband. He does not mention it one single time in an hours-long interview. And suddenly, when they find him at the last minute before trial, they find out he's been watching true crime shows about this, and suddenly he remembers this incident where she had bruises and she struggled on the sidewalk. The testimony is not credible from a former Waffle House employee and bank robber, Mr. Dixon. You heard evidence from Ms. Cooley, lived across the street. She seemed to be confused about a lot of her facts and details. Testimony was difficult to follow. But she says, oh yeah, I heard screaming and breaking glass over there all the time. There was apparently no glass left in the house. Definitely from that house. Definitely that house where Chris lived. And I know that because that's the house I went in and cleaned. I cleaned all the houses that Mr. Holyfield owned. Who's Mr. Holyfield? Holyfield didn't own that house. You heard testimony from several people. That house was owned by Christopher's parents. Miss Cooley was never in there. I think Miss Cooley's confused as to what she's talking about. But well, I definitely saw a black eye behind the glasses. And then she said a few moments later, I only saw her passing a few times when she was getting in the car to go to the grocery store. Never talked to her. Just said hi. Testimony about Saul. Oh, he had access to Saul. Well, their memory seems to be just as cloudy and hazy as a lot of people. And this is a 26-year-old case, that's understandable. But I look at the statements that were made, and I see at least 4 different versions of that story that were told. In the original detectives' reports, they said they saw him went missing while Chris worked there. And we thought it was Chris. We blamed Chris. And we never found him. And then later it turned into he stole a saw. And then later they backed off and said, well, no, he asked to borrow a saw, and we never gave it back. You heard them. Their their own witness, they had to impeach you by playing things that were in audio because they said they didn't even remember saying that. And they testified here that he took a saw, not saying he stole it, whatever. And she didn't even remember talking to me a couple weeks before that, before trial. She didn't remember telling me on the phone that, yeah, he brought it back. My apologies. Circumstantial evidence about alleged conflicts in Christopher's statement. What conflict did you hear in his statement? Inconsistencies, that was the word. There were inconsistencies in Christopher's interviews. And they play for you the interview with Mr. Stott, 2001, and then they play for you the interview with Detective Shepard in 2021. In one version of those stories, in the 2001 interview, Chris tells that the last time he ever saw Lisa, she was walking down Lee Street by the MARTA station. And he stopped to pick her up, took her up the road to Taco Bell. Right by the interstate. And when they were done talking, apparently she talked about wanting to get back together. He said that was too emotional for him at this point, and he dropped her off back at the train station. She left back north. Lee Street, MARTA station. How far is that?
Yes, court is on break. I presume they'll come back, though, after the break and give the jury instructions. And then they will go into into waiting on the jury to come back. Everybody put how long they think that it will take. I presume 2 to 3 hours. If it does, then I will come back. I was going to do a slideshow of some pictures that I found of Melissa. Let me just go in here while we're waiting. And I'll pull up some of the pictures I found. This is her. I guess after they found her, they made a reenactment. Why is it not letting me go to the next one or the one before? Pictures of her when she was younger, too. Okay. Of course, we've all seen that one. Shit. Didn't mean to show you all that. We've seen that one. This one's of her, too. When she was younger. Beautiful smile. Very beautiful smile. Not that. That's how her family should remember her. She was a beautiful young lady. They shall return soon.
Begin.
Good afternoon. I'm the last voice that you're going to hear for the state. And we get the opportunity to speak to you last because we have the burden. And in this case, we have waited 27 years to get justice for this. And at this point, ladies and gentlemen, we have proved that this defendant killed Melissa Wolfenbarger sometime in late 1998 or early of March 1999 for no other reason except for jealousy, anger, and the fact that he was about to lose control over this woman who he had for 7 years. And I'm going to ask you all to bear with me for a few moments as I tell you and show you how we've proved this case beyond a reasonable doubt. Now, as Mr. McDermott was speaking, I'm reminded of two things. One, what I was told in law school, that when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have both, you argue both. And when you have nothing, you just argue. And that's what Mr. McDermott did for about 45 years. Now, I like Mr. McDermott, but he was given a tough case. And because of the case that he was given, he just had to argue for the last 45 years. And I'm going to show you how everything that he said makes no reasonable sense. Because what we ask you as jurors is that you have to make reasonable inferences based on your common sense and reason. We ask you not to leave your common sense at the door, but you bring it into the courtroom. And there's only one reasonable conclusion in this case. And all roads, all logical roads, all roads lead to one defendant, and that is him over there. I'm then reminded of a second story. Story that I've been told a long time ago regarding a red eye. And the story goes that there was a man coming across the border, and he had a red bike. And every day he would come cross the border with a red bike that had a basket with sand. And every day as he came across the border patrol guy would say, look in the basket and say, what's in here? There's something in here. Every day the guy would come and say, nope, there's nothing in there. Ride his bike every day, happy for it. Then one day, the border patrol guy and the man on the bike was at a bar. The border patrol guy was very retired, and he speaks to the man and says, you know, all those days and all those years you were riding this bike across the border, and every day I looked and there was nothing in the basket. What were you doing? God said nothing. Congratulations on your retirement. The night keeps on going, and they're drinking a little. And the border patrol goes and says, you know what, I'm a little drunk, I'm probably not going to remember what you tell me. But tell me what you were doing. He said, no, don't worry about it. Here's another drink. It's now the end of the night. Border patrol was like, look, I'm getting ready to go home. I've been drinking a lot. I'm not going to remember what you told me. Tell me what you've been doing. He said, you know what, I was telling you. He said, you know, every day when I was coming through with the red bike, you were so focused on what was in the basket. But I was smuggling in a new red bike every single day. But because you were focused on what was in the basket, you were missing what was right in front of you. And what the defense counsel has asked you all to do is focus on all these reasonable theories. And we're going to talk about these reasonable theories in a moment. And not focus on the path that's right in front of you. And like I said to you before, the path that's right in front of you leads straight to Mr. Wolfenbarger. Straight. So let's talk about some sand in the box, the basket. Let's talk about it. First, no physical evidence. That's the first thing, right? We talked about the paint chips. Let's talk about when they went to the house. They went to the house in 2003. What happened in 2003? What do we know? Well, what we know from Dorothy is that he abruptly left in February, sometime in 1999. He didn't tell his friends he was leaving. He didn't tell Miss Dorothy, the person he would hang around with every day. He left all the clothes in the house. And what did Dorothy tell you? She had to come and clean it out. And then what did you hear? That it was remodeled. It was changed. So of course, in 2003, when they go and do it, the paint chips don't match. Now when it tells you, oh, well, paint chips stay the same, you don't know what all the remodeling was in the house because it had changed. So there wouldn't be any paint chips that matched what was in her hair. Next, we talked about the bags that his DNA is not found on. But Mr. Fawcett talked to you about that. If we believe when the last time anyone besides him seen her, we know that in February of 1999, she didn't call her mother for her birthday. We know in March of 1999, she didn't appear for the court hearing for the battery case from July. So we know she's probably deceased, I would suspect, somewhere after Christmas of 98. Probably January or so of 99. So those bags were probably in that area for at least 3 months before they found them. People could be touching the bag, not realizing that it's a head in the bag, not realizing what's in it, they're picking it up, they're putting it away, whatever they're doing, there's other DNA on there. He already told you, because that's what he told Tina, what did she tell him? Tina, Miss Parent, all of them while they were sitting at the Waffle House, he know how to hide a body. Well, I suspect he know how to use some gloves to hide the body. Suspect he knows how to use some bleach. Remember someone said it looked like there was some liquid in the bags? See, you have to remember all of the evidence that came out. Well, he had the reciprocated saw, so we only chopped up the body. Where's the torso at? But we're going to get to the torso in a moment. And he discarded it. So that's why there's no, his DNA wasn't on the bag. Let's talk about the blood, no blood at the luminol. Well, if she was strangled, there would be no blood. And is it reasonable he strangled her? Yes. You want to know why? Because her sister told you that she came in to the Waffle House in early of 1998 with strangulation marks on her neck. That's what she told you. So is it reasonable that he strangled her? Yes. So that's why there wouldn't be any blood. So that's why if they luminol, there wouldn't be there. Well, we know he strangled her. What do we know from Dorothy? He punched her. What do we know from the report? He dragged her. That's the way that he harmed her. There's no evidence that he used guns or knives. All of the evidence shows that he used his physical hands to hurt her. So is it reasonable that he strangled her? But it would be nice if we had her neck to really be able to tell you what he did. But see, they don't want to talk about that part of it. Let's talk about the pubic hairs. Well, what do we know? Thomas Dixon told you that they were intimate. What did he also tell you? The last time he saw her was in December of 1998. Could it be that the day that, remember when he said the last time I saw her, she left with him? physical evidence doesn't mean it doesn't point to him, because there's a reasonable reason why there's no physical evidence. No physical evidence. So they showed you the rain shower report. Well, the only month I see here is April. If she was died in January, February, or March, where's the rain report for those months? You have to start thinking about what they want to give you, because they want you to go all over the place and not on the right path. Her body was sitting out there for months. She was severely decomposed. What did the ME say? I can't even tell you. It could be 30 days. It could be longer than that. I submit to you it was longer than that because her mother did not hear from her in February. Let's look at the evidence, y'all. And that is evidence. That's what came out on the stand. Everything that came out on the stand is evidence. Stand in the box. Don't believe any of the state's witnesses about you. So everybody lying. Tina doesn't know Dorothy. Remember, because I asked her. Dorothy don't know Tina. But somehow they both saw Melissa with bruises. So they both lying? Why? What would they need to lie for? Matter of fact, Miss Dorothy, if you remember, if you watched, when she came in here, she looked over at him. I guess she remember seeing him from back in the day. She kind of got a soft look on her face. And she tried to switch it up on him. If you can remember, because first I said, I asked her, did you hear her yelling? She's like, I heard both of them yelling. And I said, is that what you told me in my investigator last week? And she said, well, that's not what I said. And she changed the story. She wanted to help him. See, y'all gotta remember those little things. But then, as she was getting crossed, if you remember, she said at one point, I used to hear her scream. She said, I used to hear her scream. What did she tell you? That she heard it 3 to 4 times a week. Let's assume that they moved over to Brookline in January, February of 1998. You know, we lawyers, I don't do a lot of math. But she's 3 to 4 times a week. So say 4. So I'm good with that. 4 4 is 16. Times that by however many other months. How many times was she hearing this poor baby scream every week? But they want you to believe that no domestic violence was happening? You gotta start thinking about the evidence, y'all. Because they talk to you about that. Thomas Dixon, he don't know Dorothy. He don't know Tina. But somehow Melissa was able to tell him about what happened to her in July, but he comes in here and he's lying too. Remember when he told you that I had been in prison for about 10 years and I saw her missing face on some cards. That's how he remembered that that's how he knew she had passed. And wanted to tell everyone about what she told him. And is that unreasonable? Because maybe he was her peace and solace to get away from him. You know, he asked questions about them being on the roof of the Waffle House. Maybe that was the only place she could get some peace, on the roof of the Waffle House. From him. What did, now I know she said all she would smoke take heroin every day, but what she tell you today? That when she called her friend, the last in 1998, he didn't want her to speak to anybody. So we're supposed to disregard all of that. I submit you don't do that, because that's evidence. Now the rocks. You know, he said, I guess he claims that his rock told him on the phone that he returned the salt. He didn't play that interview for you. He played Wendy's interview. So where's that interview? The interview you heard is when the Rock said he borrowed the saw. Matter of fact, they corrected the police. The police said, he stole the saw. They're like, no, he didn't steal the saw. He borrowed the saw. And they said on their own, and he never brought it in. And they told you, that's not the reason why we fired him, but he never brought the saw back. And remember what we asked them earlier? In the culture of that job, they don't really ask what you use the saw for. They just use, they let their employees borrow the saw. That's evidence. Because how ironic is it that her body and the bones have lines from a reciprocating saw that he's so having to borrow from the job that he worked in. And it hasn't been returned. Ladies and gentlemen, this is evidence. And then, this whole thing that he was cooperative, he gave DNA samples, he did this. Well, he did those things because he believed he covered up the murder. He believed that he did what he needed to do to cover up the murder. But when it is time to now be held accountable, what is he doing? And we're going to see the video of that in a moment. He first sends his girlfriend out to say he's not home. They skip over that part. When the police get there, she opens up the door, she comes out and says he's not there. But what did O'Hare say? Because of the cell phone, they knew he was in the house. So he kept looking. And y'all saw the video, he looked, I think he thought he was behind that mirror, he kept on going back to that mirror. And then eventually he's like, oh, he's here. And he knocks on that makeshift thing that he done cooked up some something. But he's cooperative. This is when I go through all their reasonable theories, the medical exam. What did she tell you? In her expert opinion, she did not die of natural causes. It was undetermined by highly likely homicidal violence. And what did she tell you? If we only had the torso. And why would we not have the torso? Could it be because she was pregnant? And he wanted to make sure that we never found that part of her. So you're going to get this instruction from the court, and this is what both Mr. Fawcett and Ms. McDermott discussed. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories. Reasonable. Your duty, when you go back, a reasonable doubt is a doubt of a fair-minded and partial juror honestly seeking the truth. It's not arbitrary, it's not vague. So let's talk about their reasonable theories. So the first one, a random person in the West End decided to kill her child, decapitate her and cut off her legs. What evidence is there? There's no evidence. The only evidence of her walking down the street comes from the defendant, who has all reason to lie. We're going to talk about when he says this idea of her walking down the street. That she's hanging out with people who do drugs and alcohol. Who? Who? That's not reasonable. There's no evidence of it. Next is the male, they don't have his name, who molested her as a child. What evidence is it that he came from wherever he may live to come all the way to Atlanta to kill her, to use a saw to cut her, to put her in a bag, to discard her across the street from his job? deal gone bad? Since when is she a drug dealer? Where's that coming from? An overdose? What you heard is that most people, everyone's trying to keep her away from drugs. Remember Wendy said when she was doing meth, she didn't want her to do the meth. What did Tina say? I was doing my thing. I didn't have my sister around me when I was doing my thing. So where's this evidence? They're throwing things to the wall, see something was there. Suicide. Well, the enemy told you that that's not the case. Would you gonna kill yourself? Or why would someone, like, that doesn't make sense. So someone finds you dead and now they feel like they need to discard your body in a way. Why would they just leave you there? If it was a suicide. And then Carl and Norma Patton. You know, when Mr. McDermott said, we're not saying it's Carl and Norma Patton, my mouth dropped. Every cross-examination was about what Norma and Carl did. That they had something happened in their living room. That Norma helped them in the living room. But what they didn't talk about is that Carl and Norma were looking for their baby when they didn't hear from her in February 1990. That they drove from their home in Stockbridge to go look for their child. That even when Mr. Petty got arrested in 2003, the first thing he wanted to do said, you got me, go find the person who killed my child. That's what he said. Norma said, look, you got me, I'll testify against my husband. Find the person who killed my child. And they want you to believe that those are the two people who killed their daughter for what reason? Oh, now she wanted money. Most kids want money from their parents. I think I still ask my dad for money every day. That means he's going to kill me? Because I asked for money? Most people want to take care of their children, protect their children. You have to make it make sense, and it does. So we talked about this, but you get to decide who you believe. You know, when you have Miss Patton, Tina, look at their testimony in comparison to Kimberly, his sister, compared to Kathy, his mother. You can assess that. Why is it that Kimberly and Kathy can't remember a thing? Nothing. Nothing. I don't know. I don't know. You don't remember anything? Kimberly, that's your best friend. She was with you when you were driving on the road. And you don't remember anything about what she told you about your brother? But yet, Calhoun can come in here and tell you, you said that she wanted to leave your brother. She loved your brother. She wanted to leave. She can't remember that. Why? Is it because remembering that will show that she wanted to leave your brother? And she don't want to be with your brother anymore? Mom can't remember that she never used to talk about Melissa to her grandkids? She can't remember if she went to go look for her or not? Why? But they don't want you to believe Norma and Tina. And Norma came in here and told you, this is what I did, this is what happened. She remembered everything that happened. She corrected us at times. But they want you to be so concerned about her past that you're not listening to what she's telling you right here today. I submit to you, don't fall there. Don't fall there. Your duty is to seek the truth, follow the law, and deliberate. If for some reason you want to back and one of your members say, I don't want to deliberate, they go hide in the bathroom, you come out and you shut the judge. You don't come out, but you should write it and let the court know that one of your members not deliberating. So let's talk about how we prove that he is. We don't have to prove motive. However, any evidence of motive is admitted for your use in determining the defendant's state of mind at the time of offense. This isn't a domestic violence case. This is a case of domestic violence. This defendant used his power and control from the time that she was 15. From the time that she was running out the house, from the time she was running away with him, he began to control her. What did Wendy say? She's easily controlled. She's a follower. That she's acceptable. She's going. And he knew this. She's stealing cars for him or with him. She's out here leaving the house, trying to be with him. And the mom said, I didn't like the boy from the time I saw him at 15. Sometimes that's just a mother's intuition. Tension building. Tension building. What did Dorothy tell you? The argument. That's tension building. The breaking of the glass. That's tension building. The incident. The marks on the neck. The incident. The July incident. The incident. The black eye that Dorothy saw. Those are all incidents. And those are what people saw. We know sometimes domestic violence happens in the house of things that people will never see. The reconciliation. Her wanting to go back to him. The TPO hearing where she drops the TPO.
Your Honor, we would approach.
Sure.
The TPO hearing. The reconciliation of it. That is evidence of a domestic violence relationship. And if there was a calm period, she went back. We know that he went to court with her, so those could have been times of that calming period. We talked about the different ways in which we exert power and control. So let's talk about some of the ways of exerting power and control. Isolation. What did we learn? When she got to Brookline, she didn't have any friends. What did Kimberly tell you? I started living my life. So we weren't friends anymore. What did Wendy tell you? They weren't friends anymore. What did her sisters tell you? That, we started hanging out again more and more once she started working at the Waffle House. So her connections weren't there. Her connections were down in Stockbridge. She was naive, easily influenced, believed what anyone tells her. We talked about the physical violence. Using her children. I submit what happened in that room when the judge allowed them to talk is that he convinced her his mom and kids. And she did. You give permanent custody permanent guardianship to my mother. And that is a form of control. Now your mother, the abuser's mother, now has her children, can dictate what the children do. We know that they didn't tell them about their mother. what did Ms. J tell us about the role of a perpetrator? Plays the hero, the judge, and the victim. He's a hero when he's saving her from the house. A hero when he's taking her from the home. When she's running over to his support. He judged her when she wants to go back and be with her family, spend time with her family. Not allow her to talk to her family. And then when she finally decides that she's tired and enough is enough, as she told Kimberly that I was done, he plays the victim. You can't leave me. Look what I've done for you. Look at how we are in my grandmother's home together. Look at how I saved you from your family, saved you from your trauma, saved you. You can't leave me. Abusive, we already talked about it. He was controlling. She was, Melissa, fragile-minded, a follower, easy to control, weak, not protect and fight, naive, dependent. Again, evidence of his controlling behavior. Motive, pregnant by another man. Because remember Thomas said it, thought it was his. And leaving him for another man. And what did Rosa tell us? The most violent time for a victim of domestic violence is when she wants to leave. Is when she wants to leave. And she was leaving him. She found solace in Mr. Dixon. And he was going to lose control of her. That is why he killed her. She was going to leave him. She was leaving him. Now let's go through a timeline very quickly. Late 1997, early 1998. She goes to Waffle House crying with a bruise on her neck. Melissa indicates to her sister that Chris caused the mark on her neck. She initially tries to confront Christopher. Melissa doesn't want her to confront him. Troy instead hits Chris. Tina drops Melissa home and confronts Chris about hitting her sister. That's on 2 separate times. And then you know about the time at the Waffle House where he makes an ugly comment. He knows how to hide a dead body. January through March of 1998, Melissa moved to the grandparents' house on Brookline, again away from her family and friends. She's working at the Waffle House in New York. Remember? So Melissa, March of 1998, Melissa visits her sister at Waffle House on Virginia Avenue and surprises her for her birthday. Remember when Tina testified, she said, I thought it was 99, but my mom did correct me and I realized it was 1998 and she remembered the wrestling people coming in and that's how she was able to remember the date. So it was 1998. And we know it's not 1999 because if you believe what her mother tells us, she did not call for the birthday and she did not appear for the court hearing in March. It's reasonable to believe she was deceased by then. Again, Melissa's still working at Waffle House in Doraville, and Christopher's not working at Action last year. He didn't start until October. January through July, we talked about this. Dorothy hears arguing, sees Melissa with glass on her face and blue in her eye. She saw Melissa with a baby maybe once or twice. You know about the July 21st APD police report. Melissa applies for a protective order. She seeks petition to terminate guardianship on the 23rd. Temporary protective order hearing. Chris is allowed to speak with Melissa privately. That's when, after that meeting, is when Melissa asked for the TPO to be dropped. On the same day, she asked her mother to pick up the children from daycare and take them to Kathy Wolfenbarger and give permanent guardianship to Kathy Wolfenbarger. October 1998, Chris begins working at Action Glass. Melissa's probation court hearing. She tells the judge that she's pregnant. November 9, 1998, Norma sees Melissa at a court hearing. She she leaves the court hearing with Chris. This is the last time that Norma sees her daughter. Thanksgiving 1998, Wendy Waddell calls Melissa. Chris does not allow her to use the phone. He's controlling Melissa's ability to speak to her friends. Melissa does not call her family on Thanksgiving. December 98, we know that Thomas sees Melissa at the Waffle House. He says to Chris, because he comes in, Melissa's crying, you can have her after 9 o'clock p.m. Chris waits outside. Melissa leaves with Chris. He never sees her again. According to the Wolfenbarger family, they see her at a family function in December of 1998. Again, her family does not hear from her. February 1999, she doesn't call her mother for her birthday. Carl Patton goes to Tina's job to inquire about Melissa's whereabouts. Christopher is fired from the job, but he had borrowed a reciprocating saw and had not returned. March 1999, Melissa is not present and cannot be located for the battery trial. April 1999, her head recovered is unidentified. Other extremities recovered, unidentified. February 99 and January 2000, we know that Ms. Norma Patton is seeking assistance to locate Melissa, reaches out to several law enforcement agencies and received no assistance. She speaks to a lawyer who puts her in touch with the Henry County Police Department. January, files the missing police report. Detective Scott assigned to the case. January 2000, Detective Scott does initial interviews with various family members to include or attempt to include Melissa's husband, the defendant. This is January 2000. About 9 months later, he speaks to Karen Wolfenbarger, and she is reluctant to speak to police or give police any contact information for Chris. 2001, he finally speaks to Chris. So it's 2.5 years after the remains are found, 18 months after the missing persons report, and 18 months before the remains are identified. And here's what he says. First, about her personality. These are his words.
Yeah, we're talking about, you got to understand, I don't know what all they told you about the mentality of her. She's not real, she didn't have a whole lot of street smarts at all. She was real smart, though. She had a lot of book smarts. She was real intelligent that way. But as far as, she was real naive, and I'm a little that way, but not quite like that. She would basically, if you could put an idea in her head and get her to thinking about it, she would swear that's right. And I guess that's why she had so much problems, running away and all the time. But she was a real follower.
He said, you put an idea in her head, she will follow. She's a follower. That's how he was able to control her. What did he say about her when she stayed with him? These are his words.
So she stayed with you for about a week, and then
She stayed with me for a few days and stuff like that. Sporadically, yeah. I'll say almost a month. I would say 3 weeks. It was right around, it was almost Christmas, I remember.
So what does he say? She was sporadically with her until about December of 1998. No other person besides Chris sees her after December of 1990. What does he say? Because this idea that it's Norma who did this, in 2001, he says this about her mother.
But there's no way I believe that she ain't called her mama. That's the whole reason I ain't even, heard it.
He said, there's no reason why she wouldn't call her mom. That I haven't been over there yet. In 2001, he figured she would be calling her mom. That's what he tells the police. So why all of a sudden now is her mom couldn't have killed her? And it corroborates what Norma said. She was concerned at Christmas when she didn't see Melissa, and she's even more concerned when she didn't hear from her on her birthday. So this is what you have to listen to. That he saw her in April of 1999.
After she left, I didn't hear too much from her for, a couple months. I was like, whatever. But back in April the following year, which I guess coming down Lee Street. I don't know if you know about Atlanta like that, but it's right there, right where the train station is in the West End. I was coming down through there, and she was walking down the road, and me just being a white girl, I was, blowing a horn because we're a dying breed around there, But I stopped and I blew the horn at her, and I got down the road, got my Krispy Kreme, turned around and come back. I'm like, I got thinking who it was, and I couldn't believe it, man. She just, I don't know, I guess her sister could tell you how she looked. You got to picture how she looked when she was right. Yeah, I got this on when that was done. Yeah, see, that was before. That was like she looked like right after we got married. After that, man, she cut all her hair short, dyed it red, started smoking. She looked totally different than that. But when I see her come back, man, she was real bad. She went off the gate and everything. I was like, man, I couldn't believe it. It broke my heart. But we stopped and she said she wanted to talk, so we went. I went up to Taco Bell. We ordered a little deal or whatever, And at that time, she was like, I made a mistake. I want to come back home. And I was like, man, you don't know the emotional stuff, whatever it's going through for me. Just like this.
So what, you said, I know it's my fault. When we finish this, you're gonna ask the county commissioners to do the system. But what he says is he saw her in April '99 when he was driving down Lee Street in the West. And that she had bright red hair and that she had track marks on her. Ladies and gentlemen, in April of 1999, her head was severely decomposed on April 29th. How is it that he saw her walking down the street and able to describe that she had short red hair? What did his mother and his sister say? The last time we saw her in December, her hair was down to here. But he sees her in April walking down the street. But she didn't call her mom. She hasn't called any of her family members, but yet he saw her and describes vividly. This is in 2001. This is before her body's identified. This is before anyone knows that the remains are hers. This is when he thought that no one would be able to find her. This is what he's telling the police in the missing persons report. And you have to remember that he abruptly leaves the neighborhood in early 1999. Why? That is your mother's home, your grandmother's home. Why would you need to leave that house abruptly? There's no reason except you have to get out that neighborhood. Let's see if this one works. He tells them later on in that same interview again that he saw her in April of 1999.
I mean, she had dyed her hair several months before, but then right there towards the end, and especially when I see her in April, her hair was real short, real bright. It was like, they look odd. She definitely stood out. I mean, she didn't like nothing like that.
So he said she had dyed her hair a few months before. No one else has seen this except for him. He also says, and I'll try to play, but if it doesn't work, we'll keep moving, that she must have changed her name. Why would Melissa need to change her name? There would be no reason for her to change her name. Why? Again, this is in 2001. He wants people to think that she's moved away and just changed her name. She already wanted to leave him. She didn't want to be with him. She already started a relationship with someone else. So what reason would she need to change her name?
I know that she would like to say, that's the only thing I think of right now. I really don't know, but that's just my opinion. And she went through, because to this day, she's still married to me. I'm not, just now, I guess going through divorce, whatever, I'm trying to do all that. But
It's not, and you, and I'll say this as a reminder, if there's any video that you would want to hear, you can do that if you're once you're doing the party. He also tells them in this same interview, you have to cut everyone off. Again, why would she need to do this? She had her family who loved her family who cared about her, her mother, her father who picked her up after the July 21st incident. There would be no need for her to cut anyone off. But again, he was trying to cover it up because again, this is before anyone knows who she is.
I mean, she had taken she had dyed her hair several months.
In 2002, he files for and is granted divorce from Melissa. He also says in that 2001 interview that he's been working on the divorce since 2001. If you thought she just went away, you didn't think she was gonna come back at all? Why are you filing for the divorce? You're filing because you know she's never coming back. March 18, 2003, Detective Scott and Calhoun meet with Chris. This is a few days after the remains are identified. If you remember, they kind of confirmed his story before telling him that she's been identified. And again, in this interview, he says the same thing. He saw her in March and April of 1999. Now he says he dropped her off at the train station and that was it. She just disappeared in the night. With no one else to see her. That story is a lie. And again, he's the last person to say he saw her.
Say the years disappeared. I've been sitting here, I don't know if it's 98, 99. I know 2000, I was living in Savannah, so it can't be 2000. But whatever year that they're saying that they seen her, I know I seen her like in early March or April of the next year. And that was the last time I've seen her. That's November of 98 is when they're saying. That's Thanksgiving. Right. And then so end of the next year, 99, early 99, March, April, somewhere near when you think you ran into her. And he's probably more familiar with the area than I am, but said that was Hornet. She was walking from like the Martin train station up from Brookline. Is that right? Yeah. Right there on Lee, was that Lee Street? Y'all went to a Taco Bell in the area there and talked a little bit. And what happened? She walked off, rode away, and I dropped her off back at the train station. Yeah, so you were driving. What kind of vehicle you had? I had a I want to say it's a tan color Chevy Caprice, like a brown color. I mean, I can't be certain on that because I've had got off of mini cars.
Then he says, he looked better than the last time he saw her. In 2001, she looked like she was doing something. He kept on saying track marks, but now in 2003, she looked better than the last time she saw her. I think I'm running out of time, so I'm going to speed through this pretty quickly.
What's the last?
This idea that she may have got drug overdose, what he says is she was not on drugs while they were together. So this idea, he said.
When people do stuff like that, kind of just disappear from the family and just run, have a lifestyle like that, they're already on drugs. That's what I'm trying to say. Oh yeah, she wasn't on nothing when we were together. I'll say we smoke reefer every now and then, just whenever we go to concerts or something, or go out or something, we might drink regular alcohol or something.
She went on drugs. So all of a sudden, the defense is, she may have had a drug overdose. He says it. And it's in 2003. He talks about the divorce being final. We don't need to say that clear. She wasn't afraid of her dad or anyone getting revenge.
Was she ever afraid either of him or somebody that, might be trying to get revenge? No, against him? I don't know if she did. She never let on nothing like that. She never acted that way. She was always more quiet or didn't.
So now all of a sudden somebody wants to get revenge on her? That's not what he said.
I was just getting at how much you knew, whether she was ever afraid of him. You know, she was afraid of her mom, but she couldn't stand her mom. I'm not really sure that's what, that's what's got me starting now or whatever, because, I mean, it always seemed to me like, she loved her dad, with her dad, but her mom was always, every time she run away or whatever, she would come and tell me she was running away from her mom. I mean, I don't know, that's why I couldn't really say, I don't know, I just couldn't see him doing anything to her. I don't know, that's why I guess that's why I can't really think she'd be dead. If there could be a homicide or whatever.
You can't see her. This is her dad doing anything. Now in May, you've heard this interview, so I won't play it. There's clips in here, but I'll highlight a few things for you. But this is the May 5th, 2021. This is now 18 years after the head and extremists have been identified, 6 years after media attention has been brought to the case. He talks about the last time he saw her. Now he doesn't really remember. And we understand that memory fades. But the defendant nor his family can remember a thing about this woman who's the mother of his child. And you heard it. You heard the interview already.
In
He thought she just left and moved on. Well, when she didn't come back, you didn't call the authorities. You didn't report her to anyone. This is the mother of your children. This is your wife. And you don't say anything? He never wanted to reach out to assist her own family, became worried. He didn't even want to speak to the police. Back in 2001. It took him 18 months to do this. Why?
When she was leaving, go.
Now, all of a sudden, her parents killed her. In 2003, there's no way her dad could do it. But now that the media's been on it, now that it's been highlighted, now that the road is leading to him, he says her parents did it. And that's convenient. Let's blame the individual who was accused of a accused of killing multiple people, and let's blame him.
What do you think happened to Melissa?
2023, the thing of police meeting with Captain Wolfenbarger, investigation continues. And then here he is, hiding behind the wine rack in here. And he's hiding just like he told his daughter. When I have to go on the run, because that's what he told him, when I have to do it, I know where to go. You saw Christina here. She had no reason to make that up. And that's exactly what he did. Had a makeshift place to go hide. Now they said that we want you to do a leap of logic. No, we don't. We want you to follow the path. Physical abuse at 98. Mom sees her last time in November of 98. She wants to leave him. He borrows a reciprocated assault and never returns it. She does not call her mother for the holidays. He does not appear for the March battery. She doesn't appear for the March battery trial. Carl Patton goes looking for his daughter. He abruptly leaves the neighborhood without telling anyone, leaving all of his clothes. Her head is found on April 29th, across from his job, severely decomposed. Extremities found in June, across from his job. He's the only person familiar with that neighborhood. His mom doesn't know where to go. What did Ms. Patton say? The only time we went up there is when we went to go pick her up. They're not familiar with Atlanta. He is. Cut marks on her bones appear to be done by reciprocated assault, consistent with the type that he took from the job. Her torso never recovered. Could it be because she was pregnant? He never reports his wife missing. Reported missing by her mom in January. Mom's reluctant to give information. He lies to police in September. Never speaks to his children about their mother. Body parts found in ATL. No other family resides here. This is where everything is found, from the house to his job to the location of the house. This is not a legal obliging. We're not asking you to jump. We're asking you to follow the path. And all the evidence leads to one conclusion. He's guilty. Now, ladies and gentlemen, we might not have all the puzzles. We wish we had her torso. He was clever enough not to leave DNA. But what we do have is this. You can still see this dollar bill, even with all of the missing pieces. You still see that the path leads to only one person, only one conclusion. Now, sometimes things are challenging, and this is going to be hard for you all to see. But this young lady right here should not have been left like that. This young lady deserves to have raised her children. This young lady deserved to have lived a life. This lady deserved to have continued to work, to be a part of her children's lives, her grandchildren's lives, but she is not. The defense has operated on what if this, what if these possibilities? What if? We want you to focus on what evidence came out of the trial, what the reasonable conclusion is, and you will not be telling him something that isn't already known. For 27 years, he's known what he has done. For 27 years, he has sat and hid from justice. We are imploring you, we are asking you, don't listen to these fabricated stories for what the defense is telling you. When you follow the truth, when you seek the truth, there is only one true result. That this defendant, Mr. Wolfenbarger, is guilty of murder. And we're going to ask that you do that. Evil prevails when the men and women fail to act. I'm asking you to act. We are asking you to act. And we are asking you to find him guilty. Thank you.
Thank you. Ladies and gentlemen, I'm going to, in a moment, just give you the charge of the court, which is that law that I promised when I first swore you in to be jurors in this case. And I, too, have a PowerPoint. And mostly I do that so that people process things differently. And so some people hear things better and understand it by hearing it. Some people, it's helpful for them to see it. You will have a copy of these jury instructions with you in the jury room while you deliberate.
Thank you.
Ladies and gentlemen, you are considering the case of the state of Georgia versus Christopher Wolfenbarger.
Now, the lawyers have referred to some of the governing rules of law in their arguments, and if there is any difference in the law that was stated by the lawyers and as stated in these instructions, you are governed by these instructions. Nothing I say in these instructions indicates that I have any opinion about the facts. You, not I, have the duty to determine the facts. You must perform your duty as jurors without bias or prejudice to any party. The law does not permit you to be controlled by sympathy, prejudice, or public opinion. All parties expect that you will carefully and impartially consider all the evidence, follow the law, and reach a just verdict, regardless of the consequences. Excuse me. You have been selected and sworn to try the criminal case of the state of Georgia versus Christopher Wolfenbarger. The Fulton County Grand Jury has indicted Christopher Wolfenbarger for murder. I will now read you that indictment. In the state of Georgia, In the county of Fulton and the Superior Court of said county, the grand jurors selected, chosen, and sworn for the county of Fulton in the name and behalf of the citizens of Georgia do charge and accuse Christopher Wolfenbarger with the offense of murder. For the said accused in the county of Fulton and the state of Georgia, sometime between the 10th day of December 1998 and the 29th day of April 1999,
exact date being unknown to the grand jurors at this time, did unlawfully and with malice aforethought cause the death of Melissa Dawn Wolfenbarger, a human being, by inflicting homicidal violence upon her in a manner unknown to the grand jurors at this time, contrary to the laws of said state, the good order,
peace, and dignity thereof. Ladies and gentlemen, you will have the indictment with you in the jury room, along with a copy of these instructions and a verdict form. The defendant has pleaded not guilty to this indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing crimes that violate the laws of Georgia. The charge in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charge or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. The defendant begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crime charged. You may not convict the defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on the consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. After considering all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendant not guilty. But if no reasonable doubt exists in your mind, about the defendant's guilt, then you may convict the defendant. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented, and then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, or other physical items that are admitted during trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Evidence may be either direct or circumstantial or both.
Considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts or circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give
to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. In determining the credibility of a witness, you may consider evidence offered to attack, challenge, or cast doubt on the witness's credibility. This may include evidence of criminal convictions as shown by proof that the witness has been convicted of the offense of a felony or a crime of dishonesty. Your assessment of a witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, a defendant does not have to present any evidence or testify. And when a defendant chooses not to testify, you may not consider that in any way in making your decision. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. It is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify a defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that a defendant show that another person committed the alleged offense. If you do not believe that a defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of a defendant as the person who committed the crime alleged in this bill of indictment. Defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. A defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. A person commits malice murder when that person causes the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did commit the offense as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of any defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual orientation, local or remote residence, or economic status for or against either party. You are only concerned with the guilt or innocence of this defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with fellow jurors.
Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only only to in-person communication, but also to communication or research using cell phones, text messages, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is, agreed by all. The verdict must be signed in ink by one of your members as foreperson, dated, and returned to be published in open court. The alternate jurors are jurors 43 and 45. You will be given separate. The deputy. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. If you have any questions during your deliberations, please write them out and give them to the deputy. If you wish to take a break during your deliberations, please notify the deputy. But please understand that you may deliberate only when all of you are together as a group in the jury room. Deputy, please escort the jury to the jury room. And ladies and gentlemen, your lunch is there and ready for you. Thank you all. The jury is clear. You may be seated. Any objection to the charge as I gave it from the state?
No, Your Honor.
From the defense?
The objections are the ones that we announced before. Are we preserved, or you want me to reiterate what they are? It was the
As far as I'm concerned, they are preserved, Mr. Samuel. The objections that you have already asserted, you had preserved them when I said this is the charge I intend to give. You indicated that you continue to object, and I've, of course, now given them, so you can object again.
You want me to object again? Okay, the 404B instructions we requested.
Yes, sir.
There were 2 or 3 of those. And the prior difficulties instruction, we think both of which were necessary in this case.
Okay. I do, forgive me for interrupting, I do want to make a note. There was an objection during the closing argument, the second part of the state's closing argument, as to Ms. Hilton. The parties approached. I notified the parties that I would make a note of it and make a record of that objection. The objection was to I think it was a statement by the state regarding actions by Melissa Wolfenbarger in stealing cars, and that somehow that was with or for Christopher Wolfenbarger, I think was what I understood. The discussion that was had at the bench was, number one, that's 404B evidence that was never, that was not appropriate and would not have been admissible, but also I had not heard any evidence about Mr. Wolfenbarger's connection to those alleged car thefts by Ms. Wolfenbarger until that moment. In any event, the objection was preserved, and the party stepped back and the state agreed to move on from that issue rather than highlighting it by withdrawing it. Anything else you want to put on the record regarding that issue, Mr. McDermott?
No, Your Honor.
Ms. Hilton?
No, Your Honor.
Anything else for the defense, Mr. Samuel? I interrupted you, sorry.
You didn't interrupt me.
Okay.
Thank you.
Okay, so can y'all please make sure that y'all have all the evidence together, and that to get it ready to go back to the jury? Deputy, my understanding is that the alternates, Judge Williams has graciously agreed to loan us her jury room for the alternates.
Yes.
So you can, once they get their lunch, you can, and it's time for these jurors to deliberate, and we can take them over there.
Yes, Your Honor.
Okay, if y'all can check and get the exhibits together.
Thank you for watching. It's not been that long of a trial, or usually they're much longer. But as soon as they have a verdict, I will watch, and we will come back and watch the verdict together. They did get handed the verdict. It was about 2:33, I believe. Of course, they're having their lunch, but they will debate. So I will see you whatever they have figured it. They have reached a verdict, which is hopefully soon, and hopefully guilty. Thank you all so much.